Madam Speaker, Mr. President, Mr. Deputy President, members of the National Executive, honorable members of the National Assembly, esteemed justices of the judiciary, honorable ministers heading all organs of state, security forces defending the supremacy of the Constitution and the rule of law, fellow South Africans. Lord bless Africa. May her glory be lifted high. Hear our prayers. Lord bless us, your children. Lord, we ask you to protect our nation, intervene and end all conflicts. Protect us. Protect our nation. Protect South Africa. South Africa, from the blue of our skies, from the depths of our seas, over our everlasting mountains, where the echoing crags resound. Sound the call to come together, and united we shall stand. Let us live and enjoy freedom in the universe, our home. The legislature must be faithful to the Republic of South Africa and obey, respect, and uphold the Constitution and all other law in the Republic, as it undertook to hold office with honor and dignity, whose members are true and faithful councillors performing their functions of office conscientiously and to the best of their ability in relation to ID number as indicated in the notice of motion on page 1 and the force number 99004046 MC. In the matter between the 6th President of the Republic of South Africa, Lieutenant Commander Sylvester Volane Madala Mangolele, which is the plaintiff, and the state, which is the first defendant, the 5th President, which is the second defendant, Speaker of Parliament, which is the third defendant, quorum to the Constitutional Court case number 12 of 2020, which is the fourth defendant. In a notice of motion, be pleased to take notice that the 6th President, Lieutenant Commander Sylvester Volane Madala Mangolele, hereinafter referred to as the plaintiff, act in terms of Section 84(2)(d) of the Constitution of the Republic of South Africa, Act 108 of 1996, hereinafter referred to as the Constitution, to summon the National Assembly, the National Council of Provinces or Parliament to an extraordinary sitting on 17 September 2021 at 10:00 to conduct special business as provided for in terms of Section 180C of the Constitution concerning the administration of justice that is not dealt with in the Constitution, including the participation of people other than judicial officers in court decision for an order in the following terms. Enrolling this matter in terms of Rule 130 of the National Assembly Rules, declaring that the axiom, "Let us live and strive for freedom in South Africa, our land," be replaced with "Let us live and enjoy freedom in the universe, our home," in terms of Section 4 of the Constitution. Declaring that the plaintiff be not deprived of property, arbitrarily or without just cause since 20 June 2018 as guaranteed in terms of Section 25 of the Constitution. Declaring that the plaintiff is not convicted to imprisonment for 5 years on account of offensive behavior in terms of Section 105 of the Defense Act as unlawfully and intentionally misrepresented in the DoD PESOL system since 8 August 2018. Declaring that the plaintiff is not sentenced, or there is no sentence involving discharge or dismissal was ever imposed upon the plaintiff under the code as obligated in terms of Section 59(1)(d) of the Defense Act as unlawfully and intentionally misrepresented since 17 August 2018. Declaring that in no event did the second defendant cancel the plaintiff's permanent commission as obligated in terms of Section 54(3)(a) of the Defense Act. Declaring that the plaintiff was not heard or granted an opportunity of being heard by the Honorable Davis J. on 14 September 2018 as obligated in terms of Section 21(b) of the Vexatious Proceedings Act 3 of 1956, and rescind in terms of Section 21(c) therein the order issued under case number 15141 of 2018. Declaring that, antithetical to the Constitutional Court order issued in terms of case number CCT 12 of 2020, the plaintiff's rights to human dignity and life are entirely protected by the table of non-derogable rights in the Bill of Rights of the Constitution, and that the best interest of Nyiko Mangolele and Aluta Songelwa or any other child are of paramount importance in every matter concerning the child. Declaring the immediate retrospective reinstatement of the plaintiff's salary benefits and allowances to be paid into the following banking details on record of the National Assembly. Approve the plaintiff's travel arrangement at the first defendant's expense from Cape Town to Mokgogelo for the plaintiff to see the 83-years-old Leta Kokonana Majila before it is too late. The second defendant, which is the President, to, in terms of Section 84(2)(j) of the Constitution, pardon or reprieve the plaintiff and remitting any fines, penalties, or forfeitures. The second defendant must, in terms of Section 84(k) of the Constitution, confer honors to the plaintiff. Compel the first defendant to fulfill the obligations imposed by the Constitution to respect, protect, promote, and fulfill the plaintiff's rights enshrined in the Bill of Rights as obligated in terms of Section 7(2) of the Constitution. In terms of Section 89 of the Constitution, remove the second defendant on the grounds of a serious violation of the Constitution or the law, serious misconduct, inability to perform functions of office. remove the third defendant from office by resolution as obligated in terms of Section 52(4) of the Constitution. Call for the removal of the fourth defendants by resolution as obligated in terms of Section 1771B of the Constitution, and defendants be ordered to pay cost. All defendants are called to admit or deny each terms submitted in support of this notice of motion before the National Assembly. The plaintiff's code of conduct is that the plaintiff serve and defend the country and its people in accordance with the Constitution and the law, and with honor, dignity, courage, and integrity. The plaintiff serve in the South African National Defence Force with loyalty and pride, as a citizen and a volunteer. The plaintiff will not advance or harm the interest of any political party or organization. The plaintiff will accept personal responsibility for his actions. The plaintiff will obey all lawful commands and respect all his superiors. The plaintiff will refuse to obey and manifest an obviously illegal order. The plaintiff will carry out his mission with courage and assist his comrade in arms, even at the risk of his own life. The plaintiff will treat all people fairly and respect their rights and dignity at all times, regardless of race, ethnicity, gender, culture, language, or sexual orientation. The plaintiff will respect and support his subordinates and treat them fairly. The plaintiff will not abuse his authority, position, or public funds for personal gain, political motive, or any other reason. The plaintiff will report criminal activity, corruption, and misconduct to the appropriate authority. The plaintiff will improve the capabilities of the South African National Defence Force by maintaining discipline, safeguarding property, developing skills and knowledge, and performing his duties diligently and professionally. Madam Speaker or Chairperson, I put it to the National Assembly that the Universal Declaration of Human Rights and the Constitution of the Republic of South Africa guarantees human rights for all people, including me and you. In simple terms, the rights of all people are the same. Yet I am made, by the law, a criminal, not because of what I have done, but because of what I stand for, because of what I think, because of my conscience. Can it be any wonder to anybody that such conditions make a man an outlaw of society? Can it be wonder that such a man, having been outlawed by the government he serves and defends, should be prepared to lead a life of an outlaw in a democratic republic, as I have led for the past 3 years according to the evidence already before the legislature? It has not been easy for me during the past period to live without my children and family, having to ask people for their hard-earned money and space to live, so as to babysit an unlawful and intentional misrepresentation that causes actual or potential prejudice to myself, family, country, and its people, as a result of indecision by the criminal justice system which constantly fail to provide me equal protection and benefit of the law guaranteed in the Bill of Rights. Under the administration of the second defendant, the obligations imposed by the Constitution are achieved in the opposite. The Constitution obligates that people be treated fairly and not be detained without trial. And the reality is that people are arbitrarily or without just cause detained without trial, causing a reality in which the accused person is presumed guilty until proven innocent. This is not what I want my children to inherit as a legacy of a system of oppression by one another. The Magna Carta, the American Declaration of Independence, the Petition of Rights, the Hague Convention on Children's Rights, the African Charter of Children's Rights, and the Bill of Rights are documents which are held in veneration by Democrats throughout the world. It is best that the Legislature gives due regard to them. Madam Speaker, I have great respect for political institutions and for the country's system of justice, including the independence and impartiality of the judiciary, which never fail to arouse my admiration. My reality today is that I am presumed guilty until proven innocent without being given any chance to even prove my innocence, the opposite of the context of law. This is not only my reality, but that of many fellow South Africans detained without trial and overcrowding the prisons of the country I serve and defend in accordance with the Constitution and the law. Corruption in all organs of our state has reduced my admiration into despair, a reality threatening the Constitution, the territorial integrity and national sovereignty of the Republic and our democracy. I am duty-bound to my country and its people to eliminate this threat, and I am afraid that I cannot turn a blind eye to this threat as many people, including the incumbent fifth president, Mr. Cyril Ramaphosa, do, and individualize matters to say, it is none of my business. It is perhaps difficult for the judiciary of South Africa, with an ingrained prejudice against black people who represent themselves as I do, to understand the reality of their advances to the record of court. But to me, the reasons are obvious. Theoretical differences amongst those fighting against oppression are a luxury we cannot afford at this stage. Apartheid is real in our country. The lack of human dignity experienced by Africans is a direct result of the policy of white supremacy. White supremacy implies black inferiority. Legislation designed to preserve white supremacy entrenches this notion. My reality is proof of that. The Public Safety Act of 1953 empowered government to declare martial law and detain people without trial. Criminal Law Amendment Act of 1953 authorized corporal punishment for defiers. Population Registration Act of 1950 authorized government officially to classify all South Africans according to race, the sine qua non of the Republic of South Africa. The Group Areas Act of 1950 was the foundation of residential apartheid, as it initiated the eon of forced removals. The Land Act of 1913 is my current reality. In simple apartheid terms, Madam Speaker, the 1950 Suppression of Communism Act was invoked to ban me from Simonstown jurisdiction area. To ban a person, the Chief Justice simply ordered it so. To violate or ignore a banning order was to invite imprisonment, as is the case. Madam Speaker, the ideological creed of the South African National Defense Force is, and always has been, the creed to protect and defend the Constitution, the territorial integrity and national sovereignty of the Republic and our democracy. Any soldier, as I am, is a tool relied upon by our country and its people to achieve this creed. I dare not fail the South African Naval Officer Corps as the only armed force in the Republic drilling with a sword. A sword represents words and thoughts. As apartheid is white supremacy, the Constitution is the supreme law of the Republic, and the first obligation to be defended and protected by any member of the South African National Defense Force. Crime is when a person violates the provisions and/or obligations imposed by the supremacy of the Constitution and the rule of law. Madam Speaker, the supremacy of the Constitution and the rule of law is what wins in the end. No words, amount of money, or position in society will change the irreparable harm I have suffered in the hands of the incumbent fifth president and his administration that supports criminal activity, corruption, apartheid or misconduct, and guilty of crimes against the state and the administration of justice with the intention of unlawfully impairing, violating, threatening or endangering the existence, independence or security of the Republic, unlawfully changing the constitutional structure of the Republic, unlawfully overthrowing the government of the Republic, or unlawfully coercing the government of the Republic by violence into any action or into refraining from any action. No one is above the law. All are equal before the law. And the incumbent fifth president, Mr. Cyril Ramaphosa, as Commander-in-Chief of the Defense Force, does not know that his first duty is to take care of his men. Each time I have duly called the incumbent fifth president in court was for him to simply ensure that the Constitution as the supreme law of the Republic is upheld, defended, and respected as obligated in terms of Section 83B of the Constitution. And instead of promoting the unity of the nation and that which will advance the Republic as obligated in terms of Section 83C of the Constitution, the incumbent fifth president makes sure that I am separated from my children, as is the case, and in direct assault of the statute imposed in terms of Section 8.2 of the Children's Act, which provides that all organs of state in any sphere of government and all officials, employees, and representative of an organ of state must respect, protect, and promote the rights of children contained in the Children's Act. And the provisions of the Children's Act binds both natural or juristic persons to the extent that is applicable, taking into account the nature of the right and the nature of any duty imposed by the right. See Section 8.3 of the Children's Act. What has been achieved on the name of Sylvester Volane Madala Mangolele is in direct contrast of human dignity, the achievement of equality and the advancement of human rights and freedoms as the number one founding value of the Republic of South Africa as one sovereign democratic state. To ensure accountability, responsiveness, and openness, universal adult suffrage, a national common voters' roll, regular elections, and multi-party system of democratic government are values enshrined in the Constitution, in which we, the people of South Africa, recognize the injustices of our past, honor those who suffered for justice and freedom in our land, respect those who have worked to build and develop our country, and believe that South Africa belongs to all who live in it, united in our diversity. We therefore, through our freely elected representatives, adopt this Constitution as the supreme law of the Republic, so as to heal the divisions of the past and establish a society based on democratic values, social justice, and fundamental human rights. Lay the foundation for a democratic and open society in which government is based on the will of the people and every citizen is equally protected by law. Improve the quality of life of all citizens and free the potential of each person, and build a united and democratic South Africa able to take its rightful place as a sovereign state in the family of nations. May God protect our people. Nkosi sikelela iAfrika, morena boloka setjhaba sa heso. God sien South Africa. God bless South Africa. Hosi katekisa Afrika, Muzimu futuzeza Afrika. Internal arrangement, proceedings and procedures of National Assembly in terms of Section 57(1)(b) of the Constitution. Number 1. The National Assembly may make rules and orders concerning its business with due regard to representative and participatory democracy, accountability, transparency, and public involvement as obligated in terms of Section 57(1)(b) of the Constitution, which further imposes an obligation at Section 34 that everyone has the right to have any dispute that can be resolved by the application of law decided in a fair public hearing before a court or, where appropriate, another independent and impartial tribunal or forum. The National Assembly is the appropriate independent and impartial tribunal or forum obligated in terms of Rule 3.3 of the National Assembly rules to strictly adhere to the rules. A request to have response recorded by persons other than members is in terms of Rule 359, in which the Secretary must refer to the Speaker any written request to have a response recorded by a person other than a member regarding a statement or remark made by an Assembly member, a Cabinet member, or a witness in or before the Assembly, a committee or other forum of the Assembly, or in or before a joint sitting of the House or a joint committee, and any person, including the incumbent fifth president, may may be summoned to appear before the House or a committee or other forum of the House in accordance with Section 14 to Section 17 of the Powers and Privileges Act, provided for in terms of Rule 360 of the National Assembly Rules. The Secretary is responsible for the regulation of all matters connected with the business of the National Assembly, subject to such directions as he or she may receive from the Speaker or the House. See Rule 367 of the Rules of the National Assembly. Urgent matters of national public importance is regulated in terms of Rule 130, and the Speaker is requested to schedule without delay an urgent matter of national public importance for discussion by the House. In compliance with the provisions of Rule 132 in relation to motivating why the matter is of urgent a nature that it should be dealt with in terms of this rule is owed, but not limited to, the plaintiff moving in terms of Section 1995 of the Constitution and begs the indulgence of the National Assembly to a dispute that can be resolved by the application of law decided in a fair public hearing. In an urgent action for a declaratory order in terms of the notice of motion on crimes against the state and the administration of justice, in which the defendants are called to defend a charge of high treason, wherein as persons owing allegiance to the Republic of South Africa unlawfully and intentionally engage in conduct with the intention of violating, threatening, or endangering the existence, independence, or security of the Republic, or changing the constitutional structure of the Republic, and unlawfully or intentionally coercing the government of the Republic of South Africa into refraining from any action or in relation to the plaintiff, and subsequently torturing, enslaving, or subjecting him to cruel, inhumane, degrading treatment or punishment, inter alia crimes against dignity and reputation. Thus, the urgency of this matter is the primary fact that the Constitution is the supreme law of the Republic. Law or conduct inconsistent with it is invalid, and the obligations imposed by it must be fulfilled. For all people in the country that the plaintiff services and defends with honor, dignity, courage, and integrity. And this matter is an all-encompassing national security condition in which, as a citizen of South Africa and a volunteer in the South African National Defense Force, the plaintiff is homeless, tortured, enslaved, live without freedom, peace, and safety, unable to participate fully in the process of democratic governance, deprived enjoyment to protection of fundamental rights, including unlawful and intentional denial of his parental responsibilities and rights, without access to resources and the basic necessities of life, inhabiting an environment which is detrimental to his health, well-being, and bodily integrity. Arbitrarily or without just cause deprived of salary since 8 August 2018. Presumed guilty until proven innocent, and unlawfully and intentionally deprived security of land and tenure to number 4 Cable Hill Road, Simonstown 7975, and comparable redress. Excuse me. The Speaker must, in terms of Rule 133, grant the request dependent on the urgency supra. Schedule the discussion on 17 September 2021 at 10:00 or as soon thereafter as the parties may be heard, so as to be faithful to the Republic of South Africa and in obedience, respect and upholding the Constitution and all other law of the Republic as sworn or solemnly affirmed, with the promise to perform functions of office as a member of the National Assembly to the best of the Speaker's ability, as obligated in terms of Section 48 of the Constitution. Chairperson, security of the Republic of South Africa, the plaintiff is security of the Republic, obligated in terms of Section 1995 of the Constitution, and to give effect to the principles of transparency and accountability. Multi-party parliamentary committees must have oversight of all security services in a manner determined by national legislation or other rules and orders of Parliament as provided for in Section 1998 therein. And in any event, in exercising any power or performing any duty in the defense of the Republic and matters connected therewith, the plaintiff have regard of the principle that the formulation and execution of defense policy is subject to the authority of Parliament and the National Executive as contemplated in terms of Section 2A of the Defense Act 42 of 2002. National security must be pursued in compliance with the law, including international law, and is subject to the authority of Parliament and the National Executive, in which the resolve to live in peace and harmony precludes any South African citizen from participating in armed conflict, nationally or internationally, except as provided for in terms of the Constitution or national legislation. And the plaintiff reflect the resolve of South Africans as individuals and as a nation to live as equals, to live in peace and harmony, to be free from fear and want, and to seek a better life from corrupt administration as an imposed obligation in terms of Section 198 of the Constitution. The defendants are a decline in critical capabilities which are arrested through immediate directed interventions as obligated in terms of Milestone 1 of the South African Defence Review 2014, having regard of an imposed principle at Section 2A of the Defence Act. See the application to Constitutional Court case number CC 12/2020 and how it is unlawfully and intentionally misrepresented by the fourth defendant. And other defendants agree with the fraud committed. Fraud means unlawful and intentional making of a misrepresentation that causes actual or potential prejudice to another, such as the plaintiff in this matter. Chairperson, the Defense Act in Section 104(10) imposes an obligation to be upheld by the Legislature that any person who obstructs or interferes with the defense force in the execution of its duties in terms of this Act or the Constitution is guilty of an offense and liable on conviction to a fine or imprisonment for a period not exceeding 25 years. The plaintiff is an a political commissioned officer and cannot toy or campaign to uphold, defend, and respect the Constitution as the supreme law of the Republic, as the sixth head of state, head of the national executive, and commander-in-chief of the defense force, who must promote the unity of the nation and that which will advance the Republic, as obligated in terms of Section 1995, Section 83, read with Section 2021 of the Constitution. And this is cemented by a legislative provision in terms of Section 104.13 of the Defense Act, which provides that any person who recruits or attempts to recruit any member of the regular force for membership of any trade union, and other than a military trade union which is duly authorized to act as such, or incites or attempts to incite a member of the defense force to participate in a strike, demonstration, or protest prohibited in terms of the regulations, is guilty of an offense and liable on conviction to a fine or imprisonment for a period not exceeding 5 years. Any member of the defense force or of any auxiliary service who participates in any strike or secondary strike action is guilty of an offense and liable on conviction to a fine or imprisonment for a period not exceeding 5 years. See Section 104.14 of the Defense Act. A person is guilty of an offense if he or she is in respect of the public property or state money under the control of the department without good cause, abandons, damages, or destroys any such property, or intentionally or through gross negligence fails to take effective steps to prevent unauthorized, irregular, fruitless, or wasteful expenditure as contemplated in the Public Finance Management Act 1 of 1999. Is liable upon conviction to a fine or imprisonment for a period not exceeding 10 years, as obligated in terms of Section 104.20 of the Defense Act. Any person who undermines or stifles or seeks to undermine or stifle any procedure for the redress of grievances is guilty of an offense and liable on conviction to a fine or imprisonment for a period not exceeding 5 years, as obligated in terms of Section 104.17 of the Defense Act. And Section 104.12 of the Defense Act imposes an obligation that any person who is liable to render service in the defense force by virtue of military service contract with the defense force and refuses to render such service is guilty of an offense and liable on conviction to a fine or imprisonment for a period not exceeding 1 year. Any person who is subject to this act deserts from the Defense Act is guilty of an offense and liable on conviction if he or she committed the offense while on service to imprisonment for a period not exceeding 20 years, and in any other case to imprisonment for a period not exceeding 10 years as contemplated in terms of Section 13 of Schedule 1, disciplinary and other military offenses. Lieutenant Commander Mangolele did not desert his duties in any event. The roles of the parties. Take notice that the above-named plaintiff has commenced proceedings against the above-named defendants for the relief set forth in the notice of motion to be heard on Thursday, Friday 17 September 2021 at 10:00 or as soon thereafter as the parties may be heard, a copy of which is herewith served upon you. The plaintiff, President Lieutenant Commander Sylvester Volane Madala Mangolele, defend and protect the Constitution, the territorial integrity and national sovereignty of the Republic and our democracy, as obligated by the Defense Force Service Regulations issued in terms of Section 62L of the Defense Act. The first defendant which is the state, must respect, protect, promote, and fulfill the plaintiff's rights in the Bill of Rights, as obligated in terms of Section 7(2) of the Constitution. In addition, the first defendant has a duty imposed in terms of Section 9(1) of the Prevention of Combating and Torture of Persons Act to promote awareness of the prohibition against torture, aimed at prevention and combating torture. The combating of torture. The second defendant, which is the fifth president, is the head of state and head of the national executive and commander-in-chief of the defense force, who must uphold, defend, and respect the Constitution as the supreme law of the Republic and promote the unity of the nation and that which will advance the Republic. The third defendant, Speaker of Parliament, has sworn or affirmed faithfulness to the Republic of South Africa and will obey, respect, and uphold the Constitution and all other law of the Republic, and solemnly promise to perform her functions as a member of the National Assembly to the best of her ability. The fourth defendant, and in particular the Chief Justice, is the head of the judiciary and exercises responsibility over the court's establishment and monitoring of norms and standards for the exercise of the judicial functions of the courts as obligated in terms of Section 1656 of the Constitution. The main factors to consider. The legislature must be pleased to consider that in no event did the defendant have regard of the health or well-being of the plaintiff's family, especially that of the 83-years-old Leta Kukunana Machila, as an elderly who suffers irreparable harm, while it is regulated that it is an unavoidable reality that when a soldier is recruited, her or his family becomes a part of the larger of the Defense Force family, as an institution to share in the joys, anxieties, and the sometimes unfortunate outcomes of service, including maiming and death. The legislature must be pleased to consider that in no event was the plaintiff divorce order rescinded to limit his parental responsibilities and rights to Nyiko Mangolele in terms of Section 18 of the Children's Act. The legislature must be pleased to consider that in no event did the defendants respect, protect, promote, and fulfill the rights enshrined in the Bill of Rights in relation to the plaintiff and her minor child Aluta Songelwa, while all organs of state of the first defendant in any sphere of government and all officials, employees, and representatives of an organ of the first defendant must respect and promote the rights of children contained in the Children's Act as obligated in terms of section 8(2) therein. The legislature must be pleased to consider that in no event did the second defendant cancel the permanent commission of the plaintiff's permanent commission in terms of section 54(3)(a) of the Defense Act. The legislature must be pleased to take into consideration that was the plaintiff convicted to imprisonment for 5 years in terms of section 105 of the Defense Act as unlawfully and intentionally misrepresented in the DoD PESOL system to be the lawful grounds of the alleged administrative discharge since 8 August 2018. Was a sentence involving discharge or dismissal imposed upon the plaintiff under the code as obligated in terms of section 59(1)(d) of the Defense Act, and the legislature must be pleased to consider that in no event was the plaintiff heard or granted an opportunity of being heard on 14 September 2018 in the High Court of South Africa, Western Cape Division, Cape Town, as obligated in terms of section 2(1)(b) of the Vexatious Proceedings Act 3 of 1956. And regulations to be employed or followed are as follows. I will come back to regulations. I just need to rest a bit. I just need to rest and then I will come back. Can I ask for a body break, as it pleases the National Assembly in this regard, and then I will come back again in the same tune, please.